Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been called for jury duty for this week. You will be examined for inclusion on a jury or a criminal jury. Our courtroom hours vary, but are normally from, well, in this case, our courtroom hours will be from like 1 to 5 because we have other business that we normally handle in the morning. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for meals, and at night. I have an administrative matter that I must attend to, and you will be asked as jurors today, we must give you an oath. I would ask everyone here to please raise your right hand. And once I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as jurors, so help you God? Okay, you may put your hand down. Now, ladies and gentlemen of our panel, normally the court would have to do what is called an impaneling. But at this time, the court will not have to do an impaneling because it's the court's understanding that you were impaneled on yesterday by Judge Stevens. So therefore, what we'll do, since you've been impaneled already, each and every one of you meet the qualifications and you have not exercised any excuses or exemptions. So therefore, we will go straight into what is called voir dire.
Was that 25 minutes, Your Honor?
Yeah, hold on a minute. I'll keep it.
May it please the court?
Hold on a minute. Let me get the timer.
Yes, sir.
Oh, State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Oh, we're ready.
Yeah, okay. Mr. Board, the panel is yours. You will have 25 minutes, and I'll let you know at 5 minutes, that you'll have 5 minutes left if you
Thank you.
take up your full time.
Thank you. Good afternoon, everyone. Now, my name is Daniel Boyd. I am the Assistant District Attorney here, representing the state in this case. And that includes the citizens of the county. I work for the elected district attorney, Mr. Bob Wortham. And, a lot of summonses were sent out. And I want to personally thank each and every one of you for answering the call, especially right now with COVID, everything else going on, taking busy time out of your schedules to be here for this essential part of our justice system. Now, the Constitution assures that every person accused of a crime is entitled to a trial by a jury of their peers. And that's what we're here for today. Now, this part of the trial is jury selection. It's called voir dire. It means to speak the truth. And that's what myself, Mr. Kindler, defense counsel, we're going to be asking you some questions. And we're just asking you to speak the truth. That's all we want. Now, with those questions, we're not trying to pry into your personal lives. We're not trying to embarrass anybody. We just want to pick the best jurors for this type of case. And as far as it says jury selection, it's more of a deselection process. So the more you speak up, the more you talk, the less likely it is that you're going to be on this jury. And the less you say, the more likely it is that you will be on this jury. So as the saying goes, they say, if you talk, you walk, and those who refuse to say, stay. So don't be afraid to speak up, and please participate. Now, the types of assault in Texas, there's 3 types. They have a Class C assault, and that's a offensive touching. There's a Class A misdemeanor, which is pain or bodily injury. And there's a felony, which constitutes serious bodily injury. One we're doing, Class A misdemeanor, pain or bodily injury. Now, under Texas Penal Code, section 22.01, it says a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another. And that could be including the person's spouse. What that really won't apply in this case, but the intentionally, knowingly, or recklessly causes bodily injury to another. Now, so what is bodily injury? What might be some examples of an assault? What about you, Miss? That's you, Miss Benoit?
Yes.
What could be an example of an assault? Sure. And what about you, Mr. Blaze? Getting someone with a bill. Yeah. And what about Mr. Brown? Like kicking. Sure. All of this. Punching, hitting, kicking, slapping. Does anyone know anybody in here? Does anyone know anyone that's been the victim of an assault? Miss, is it Laudano?
I had a stepson that was severely beaten in 2010 and left for dead. He played about it.
Now, with that experience, would you still be able to be fair, set that aside and be fair and impartial in this case?
I guess truthfully, it would depend on the circumstances.
Okay, if it doesn't involve, serious bodily injury or anything like that, would you still be able to set this aside, set that aside? And
I think so.
anybody else? Miss Renee? Who do you know?
I have a daughter and I have a niece.
They're victims of assault. Now, would you be able to set aside that, the assault that maybe occurred to them or whatever happened in those incidents, would you be able to set that aside and be fair and impartial in making the decision in the case?
Absolutely.
Anybody on this? Now, is there anybody, who knows anybody they feel that's been wrongfully accused of assault? Okay, we have Ms. Richards. Now, who do you know is wrongfully accused?
My husband always.
And now, even with that experience, would you be able to set that aside and still be fair and impartial? Anybody else that knows somebody that they feel has been? Now, let's see what Texas Penal Code says about bodily injury. It says bodily injury means physical pain, illness, or any impairment of your physical condition. So how might you be able to tell if someone's, according to this definition, in physical pain? What about Mr. Is it Lavitt?
Yeah.
How would you tell if someone was in physical pain?
If you're limping, they got a limp, they got holding on to their muscle.
Yeah, so you can see them kind of how they're moving.
Yeah.
What about Miss, is it Durso Segura?
Probably possibly bruises or anything.
See some visible injury to them possibly? Okay, what about, let's see if I missed it, what about Mr. Raymond Jr.?
Facial that was moving around.
Okay, yes, sir. What about someone told you, they were in pain? Maybe that, or maybe they were crying, swelling, like you said, some visible injury, redness. Now, as a prosecutor in Texas, before somebody, I can have somebody convicted of assault, there's certain elements that I have to prove. And I have to prove those beyond a reasonable doubt. Now, the elements in this offense is that I have to prove that in Jefferson County, Texas, the defendant, Tanya Drusilla Gonzalez, on or about May 24th, 2019, intentionally, knowingly, or recklessly caused bodily injury to Dissel Wagner. Now, as I said, I have to prove those things beyond a reasonable doubt. And that burden is on the state, and it's ours alone, and we embrace that. Now, there's no legal definition as far as beyond a reasonable doubt, but the courts have said it does not be beyond 100%. Basically, use your common sense. Thank God for that word reasonable in there. Now, I like to think of the trial essentially as kind of putting together a jigsaw puzzle. First off, you start off with a few pieces. You really don't know what it is. Don't know what you have a few pieces of evidence, but as you go along, you start to put those pieces together. And somewhere along the way, during that trial, you know what it is. You know what that's a picture of, beyond a reasonable doubt. Now, maybe not all the pieces were there. It wasn't 100%, wasn't perfect, but you still know beyond a reasonable doubt what is the picture. Now, look at the mental states in Texas. It says intentionally means when it is a person's conscious, objective, or desire to cause the result. Knowingly is that the person is aware that his conduct is reasonably certain to cause the result. Or recklessly, that they are aware of but disregard a substantial risk that the result will occur. Basically, on purpose. Let's look at different types of evidence. There's, in trial, you might see direct evidence, like a video, showing what happens, the physical evidence, or you might have some circumstantial evidence, which there, you have a direct showing a video of what happened. You have circumstantial, here we have the dog. Doesn't show him, we don't have a video of him tearing up the bed, but he's sitting next to the torn up bed with a guilty look on his face. So you can see how both of those types of evidence can be reliable. Even though we didn't see the dog do it, I think we have a pretty good idea of who did it in that instance. And now, what types of evidence might you expect to see in a assault case that I'm putting on? Let's see, we'll go back to Miss Benoit.
Broken arm.
Purpose of some kind of injury. What about you, Mr. Blaze? Witness statements, okay, witness testimony? And, what about Mr. Brown?
Be nice if there was a video open, but,
What about Mr. Doolin?
I expect to see some type of medical testimony or witness testimony as well as some sort of prior history between the why they're.
Okay. And what about Miss Durso Segura? To kind of corroborate that. And now, what about an officer testifying? Some body cam, of the witness saying those things. Now, let's talk about witnesses. Let's talk about witnesses' credibility. Is there anybody in here? Do all witnesses start off? Do they start off with the same credibility? As Mr. Green. They all start off with the same credibility. Now let me put it this: before a witness ever steps up there, and let's say a police officer just walks in here with a badge on and a uniform, are you going to give him more credibility or her than anyone else stepping up there? Or are you going to wait to hear everything that as far as what he testifies to?
Yes, I'll have to wait for it.
Okay. So, and that's the thing, in these cases, witness credibility, you wait until they speak, and how you determine that, if anybody's ever, hired anyone on the job or been in charge of that, you get resumes, interview those individuals, ask them questions, maybe about their qualifications, to determine whether or not you want to hire them, whether they're being truthful. But that's just kind of the same thing that myself, Mr. Kindler, be asking questions to these witnesses, and you'll be able to, decide and determine how much credibility you want to give to them based upon the evidence and also their testimony. I hate to break it to y'all. Y'all probably watch the crime shows, CSI, Law and Order. Everybody watches those, but no one's running in here with a last minute lab report saying, not gonna happen. I hate to break it to you. You're also, you're not gonna see, at least I don't expect it. We get along really well, really. Most of the defense attorneys and prosecutors here, you're not gonna see us yelling at each other or acting, so theatrical. I don't anticipate you're gonna see any of that. So it's, as you've already seen, it's probably a lot more boring than TV. But I hate to break that to y'all, but it's just the reality of it. Now, let's talk about, before we go into this, let's talk about bias. It's necessary for any fair trial that you either let myself or Mr. Kindler know if you have a bias with regard to making it possible for you to make a fair and impartial decision based on the law. Each of us, sometimes we have certain life experiences that have shaped us to where we can't be necessarily fair on a certain case. And that's okay. You might be a good juror for a different type of case. But if you just let us know, for example, if you're a victim on a burglary last night, you might not be a good juror to sit on a burglary case. You might be okay to sit on some other type of case, but that one, you might not be a good juror. Now, does anyone believe that you can tell if someone is a person who's committed a crime just by looking at them? Nobody. And what about, what kind of job they had? What about the way they dress, which is kind of what I said. Right. Now, people who commit crimes, we know, as we see it on TV, a lot of times, Ted Bundy, different ones, they come from all walks of life, all races, all economic statuses. It's across the board, right? You can't look at someone and say, well, I know that that's a criminal. Well, in the same regard, can anyone here tell if someone's just a victim of a crime by the way they dress? By the, kind of job they have. In the same regard, people, they're victims across all sections of our society, economic statuses, races, right? Now, I'm gonna ask you all this question. Is crime a problem in our community? Who would answer, number one, not at all? What about number two? Sort of, but we have a bigger problem. What about number three? Too many people committing crime. What about number four? Absolutely, people are dying. Now, look at this other question. I believe that law enforcement in my community is, what about number one? Anybody think they're not doing enough to prevent or solve crimes? What about, they think they're doing a good job? What about overzealous in their law? Okay, I mean, it's okay to be honest. I mean, that's what we said, to speak the truth. We appreciate your honesty, and that's okay.
Cross between 23, honestly.
Okay. Yeah, thank you, and thank you for being honest about it. Now, we also have, in Texas, it's called the one witness rule. And it says that assuming that one witness and only one witness testifies, and they cover all of those elements that I described earlier that I have to prove. And that witness, you believe after listening to that witness has proved to you that the elements beyond a reasonable doubt, the law says that you can convict. And what I mean by that, and I'll pick on Miss Kim, but let's say that after jury selection, you go out to your car and there's a court reporter with a gun. She robs you of your purse or wallet and takes off. The cops show up and you tell them everything. And here you were in Jefferson County, a person you know came up with a gun. You just been sitting here with a court reporter for quite some time, and she robbed you of your purse or wallet. You're in fear of your life. You know it was a court reporter, and because you've been looking at her. And now no other witnesses were around to see it happen, and there were no video cameras that caught it on tape. But you covered all the elements. You testified that what you saw, that you were robbed, all those things beyond everything. But the cop tells you, well, without another witness, a fingerprint or a videotape of the offense, we can't file charges. But there's not always video. There's not always another witness. And that's why we have that. If you believe that witness beyond a reasonable doubt, that case is proved beyond a reasonable doubt, based off of that testimony, you can convict. Now let's talk about the defendant's rights. The defendant, Ms. Gonzalez had that Fifth Amendment right not to testify. Is there anybody in here that's going to hold that against Ms. Gonzalez if she chooses not to testify? She has the right to remain silent. She has the right to legal counsel. She has the right to a jury trial. She has the right to a presumption of innocence. She has the right of subpoena power, and also she has the right to testify if she wants. Now, the range of punishment for this type of case, we told you it's a Class A misdemeanor. The range of punishment is up to 1 year in jail and up to a $4,000 fine or probation. Now, is there anyone in here based on religious beliefs or otherwise moral belief, they just feel like they couldn't convict someone charged with assault or any crime? Anybody that feels like that? Is there anybody, who could not consider probation for someone charged with this? And again, this is based on not hearing any of the facts or evidence. This is waiting until you've heard all of that, just considering that ahead of time. Or you've heard all the facts, evidence, or everything. For anyone who couldn't consider probation.
Mr. Boyd, you have 5 more minutes.
Thank you, Ron. Is there anyone who couldn't consider jail time? In the same regard, you haven't heard anything, no facts or evidence has been presented. But before the end of that, that you just couldn't consider that up front. You just said there's no way even, I don't care how that. All right. Good. Now, does anyone know, this Miss Julie Maxey, she's with our office, the district attorney's office. Does anybody know Miss Maxey? Does anybody know myself? What about, does anybody know Mr. Kimler? What about Miss Gonzalez? Anybody know Miss Gonzalez?
I actually was on a jury, that was counsel with the defense.
Okay.
A few years ago.
Yes, sir, I appreciate it. But you're still be able to be fair and impartial, right?
Yeah, absolutely.
Yes, sir. Well, thank you all. Again, I hope I wasn't too boring, but thank you for your time for showing up today. I appreciate it. Thank you.
Mr. Kimmer?
Yeah, see that?
Yes, you may proceed.
Joe. I think just to start out, this one witness rule, there really isn't a rule anywhere when you look and says you can make on one witness. And it's up to you. Do you believe, whether you believe all parties on what they're testifying to. And certainly if you can pick a cases like a sexual assault, you've got one witness. And if you believe that witness beyond a reasonable doubt, and it establishes all the elements that are required, you should convict. But the thing is, you have to believe it beyond a reasonable doubt. There are a lot of cases where there's only one witness that can fulfill all of the requirements. But there is something called the accomplice witness rule, which I think is an exception to the idea of this one witness rule, where the state says if a person is an accomplice, like there's 2 people robbing a convenience store or something, and the accomplice witness is the only witness testifying against the defendant, there's no other evidence to support what the accomplice witness is saying, you cannot convict on the testimony of the accomplice witness alone, even though it satisfies all of the elements of the offense, and you believe the accomplice witness beyond reasonable doubt. There has to be other corroborating evidence before a conviction is legally warranted or obtainable, where it's just an accomplice witness. So there's an exception to that too. Just be aware of it if it ever comes up. The accomplice witness rule. We're not dealing with that in this case. Honestly, this is just a straightforward Class A misdemeanor assault case. I don't anticipate there's going to be any kind of complexities in the evidence or anything. How many of you, when you walked in here being seated, you saw Ms. Gonzalez sitting at the table here, ask yourselves, well, I wonder what she did wrong to be brought into court to be charged with an offense? Anybody ask yourselves that? Anybody? Mr. Raymond, where are you? Raymond? Raymond, did you ask yourself that? What did she do wrong to be in here?
I didn't know she was.
Okay. I had that one day. It's like, I thought you were the defendant. It's a fair admission. Anybody wonder what, to your mind, what did this person do wrong to me? Right? If you did, it is it's certainly understandable why you would think that, but anyone charged with a criminal offense is presumed to be innocent. The presumption, the starting point that we have is the presumption of innocence. And again, that's a presumption. You're required to start out at that point, and then it's up to the state of Texas after the charge is laid, and Judge Holmes has jurisdiction to bring in people from the community to a panel of jury to hear evidence. It becomes a burden of the state to bring forth evidence to you as the jurors to convince you beyond a reasonable doubt that the person is guilty of the offense. The person who committed the offense. Now, if the state fails to exclude every reasonable doubt that you have, that they're required to exclude, what's the verdict? what would the verdict be? Not guilty. That is not, does not guilty mean innocent. No. No, it doesn't mean, the juries find people innocent. Anybody believe that juries find people innocent? No, juries do not find people innocent. Juries find either that they're guilty or they're not. Just because somebody is not found not guilty doesn't mean factually the certainty required to say that they're innocent. It's just that the state hasn't proved guilt beyond a reasonable doubt. Now, likewise, if the state satisfies you, your burden of proof beyond a reasonable doubt is each element, what's the verdict? Guilty. Now, does that mean 100% for sure, for certain, this person actually did what the state's alleged that they did? That it's certain that they did. Anybody? Sir, what you?
No, Grant Seaver.
Okay.
No, it doesn't mean that they actually did it. This person gets convicted all the time.
Right. People are convicted beyond a reasonable doubt standard and they're found guilty. It ends up down the road, years later maybe, that they actually they're able to prove that they were innocent. Whether it be DNA or some other means that they're actually innocent. Because proof beyond a reasonable doubt is not absolutely certain. You don't know that. You aren't there to witness it. If you were able to say 100% certainty, then you'd be a witness. So on either end of what a jury is required to do, it doesn't involve certainty. You're not required to find innocence. You're not required to find 100% for sure for certain somebody committed the crime. Committed the acts of the state allegedly committed, they constitute the crime. But somewhere in between, that's what's reasonably expected of jurors, is to make that call. Now, the judge can't give you much guidance, though, in the standard that you're to apply in evaluating the state's evidence. You hear this idea of proof beyond a reasonable doubt. And you think that that's important enough that the court would give you a definition of proof beyond a reasonable doubt? Anybody? You think that's such an important idea that legally it can be defined to you? You think that that's reasonable? Well, it's not going to be defined. There's no definition that the court is going to give you. It's going to be up to each of you to decide for yourselves how high of a standard that is. And you could have 6 different opinions when you go back into the jury room about how high the standard is, and none of it would be wrong because the law says, the Court of Criminal Appeals has said that it's up to each individual juror to apply that standard as they see fit, the evidence of the state abuses, and vote their reason, their common sense, and conscience on whether the state's met that burden of proof. And they don't give you some guidance. Now, what do you think, Mr. Bean? Where are you? Bean's not here. All right. Benoit. Okay, in the front. What do you think? What does proof beyond a reasonable doubt mean? What is, how high of a standard for it?
Pretty high, I mean.
Okay. What's the result of convictions? Finding them guilty, finding the state's met their burden of proof beyond a reasonable doubt. What's the result of that? It's not a trick question. It's not a trick question. What happened? Anybody?
Convicted.
They're convicted, right? Yeah. They're convicted. So what happens as a result of the conviction? Punishment, right? And Mr. Boyd's told you that it could be up to a year in the county jail and up to a $4,000 fine. We could probably come over the time, but up to a $4,000 fine. So in this case, we're going to go to the judge to determine punishment. And certainly probation's an option, you know, that's there too. But it's there that it could be up to a year in jail. So does that, I guess, does that help you in determining how high of a standard of proof beyond a reasonable doubt is? The idea that somebody can go to jail for a year if you do find it. But the idea of being convicted and punished for something should frame how high, how difficult it is for the state to meet that burden of proof. Do you agree with that?
Yes.
Yeah. Anybody disagree with that? Kind of helps you put it in perspective, I suppose. It's just like, what do you value most? What's your name?
You can call me Chris.
Chris? Okay, Chris, your number,
What's 17?
Four.
What's your last name?
Brown.
Brown? You're 4 now. Okay. Mr. Brown, okay, Mr. Brown, Mr. Brown, what's the most important thing in your life?
Freedom.
Freedom, right? And certainly life, I guess, your kids, I can think of a couple of things. Freedom is definitely up top 2 or 3. And again, that's what we're talking about. How certain do you need to be before you're willing to potentially try somebody? And that's kind of my slant on pretty the other reason. Of course, you're free to listen to that or not, it's up to y'all to decide. But I would simply suggest to you that whatever you decide, it's a high standard. It should be a high standard. And I think the state of this year. They agree with that. So now assault. Ms. O'Donnell?
Yes,
Oh, there you go. Yes, ma'am. You said your stepson was a victim of an assault, is that right?
yes.
Was the person that, or the person or persons that assaulted them, were they prosecuted?
Well, not really. He did have a prior murder conviction that he had served, and this was another offense, and he was in jail for probably close to 2 years, and apparently cut a deal and out the door.
Okay, so this is a case then that potentially justice wasn't served, I suppose, and whether it was prosecuted?
Yeah, in our minds,
Yeah, was that in this county or another county?
yes.
What, do you mind me, I mean, if you're not comfortable talking about it, that's fine, just tell me.
Good.
That's your opportunity maybe to, vent a little bit too, but, well, what year was that? Do you remember?
April 2010,
So fairly recently.
I believe, the DA's name started with the K, I think, Nutt or.
Canal?
Canal.
So he was the one prosecuting
And
it?
he was at the time, and I
Right.
think it changed over.
So it was a felony then, right? If he
And
was
he
prosecuted.
swore to my husband's passed away since. but
Right,
He swore to my husband that there was not gonna be a deal cut.
and there was. Now, again, that's, there's a lot of things that happen up here. And I don't know what the circumstances were in that case and why, what the reason was the prosecutor did that. But the relevance of this trial, how does that affect your ability to give Ms. Gonzalez a fair trial on this misdemeanor?
I think I'm a reasonable person. My stepson was in a situation where he really shouldn't have been, but he was still
Didn't deserve what,
my child.
right, didn't deserve what happened.
Right.
Do you think that you can be fair and impartial based upon that, or is it a case that you think maybe?
I think I can. I think I can.
What are your views on self-defense? Do you think a person has the right to defend themselves in
Yes,
an
I
assault?
do.
Okay. Ms. Lene, I think you indicated your daughter or your niece, your daughter and your niece were assaulted.
They didn't pursue legal means, they just,
Okay,
they didn't press charges or anything.
did they call the police? Or?
Uh,
And again, I don't want to pry too much. If I'm prying, tell me to leave it alone. To the extent you're comfortable answering the question.
my niece did not call the police. It was a spouse.
Domestic situation.
Yes, and because of the.
You say the community, you mean family or
No, I mean the area in which she lived.
is that, well,
So, I mean,
okay.
that's it.
What about your niece, her situation?
No, that was her.
Okay, what about
That was her.
your daughter, I guess?
Yeah. She didn't, file.
Was it the same thing, like a domestic assault situation, husband or boyfriend or something?
Maybe if it was a common law husband.
Okay, so if
Oh, no, wait, he was.
there's a partner, like a domestic situation.
Yes.
Did she report it or? Okay.
She's already.
So in neither case, the criminal justice system or. So I guess you don't really have an opinion on whether the criminal justice system failed your daughter and your niece or not, because it never really didn't get initiated. This is not a domestic assault or a family assault. If it were, the judge, would have told you it's a assault, family violence. It's a different There's an assault, it's a special kind of assault, the family violence. There's no family relationship alleged by the state or dating relationship or anything alleged in this case. So the domestic situation is not going to be an issue. Is there anything about your daughter's case or your niece's case that would call you to question your ability to be fair and impartial? No, you can be fair and impartial. I'll just address that question to everyone. This is a non-family assault situation. Is there anything that any of you have experienced in your backgrounds, or your lives, or maybe your family members or close friends or relatives that would call your ability to be fair and impartial to question here? So each of you can look here and ask yourself that question. Everybody can be fair and impartial. Okay. Last thing I want to cover with you is self-defense. It's come up, I don't know if anybody can follow the Kyle Rittenhouse case. That's Wisconsin. They've got a different set of self-defense laws than Texas. But just generally, does everybody agree that you have the right to defend yourself? Obviously. Sure, you can defend yourself. Use reasonable force reasonably necessary to protect yourself in a situation. Texas is kind of unique in that situation. Again, I don't know if self-defense is going to be, you're going to get that instruction or not. It's going to be up to the judge based on the evidence at the end of the case, whether he gives you a self-defense instruction. I don't know how the evidence is going to develop, but in the event that it may be given to you, Texas requires the state, once it's raised in the judge's instruction on the law of self-defense, Texas requires the prosecution to convince you beyond a reasonable doubt that the person was not acting himself. And that's a little bit different than putting the burden on a defendant to prove self-defense. So what Texas does, what we do is the defendant has the obligation to raise the issue, your evidence of self-defense. Once they do that, there's an instruction given to the jury about the law of self-defense, and then you're told it's the state's burden to prove that the defendant was not acting. So they're right here to think that they could follow that instruction and hold the state to their burden of proving that self-defense was not acting. The defendant was not acting self-defense. It's kind of confusing. And not required defendant to prove self-defense. Seaver, yeah.
Yeah, I mean, it's like anything else, you're presumed innocent until found guilty.
Right. But the idea that they have to disprove something beyond a reasonable doubt, not just prove something, they're having to disprove something beyond a reasonable doubt. They kind of, somebody thinks that may not be fair to the state, that they have to disprove something beyond a reasonable doubt.
Makes sense.
Makes sense. And that's how seriously we take self-defense in the state. So, anyway, okay. Anybody have any questions for me? We're about to sit down. Give you a little time back. No. Okay. Thank you.
Hey, ladies and gentlemen, at this time, I'm going to ask that you follow the bailiff. You're going to step out to the hallway, and we may call some of you back in to do some follow-up questions. So at this time, we'll be in recess. Just follow the bailiff to the hall.